welcome back. I'm your host, Ariel Brown for Teen Scene. Today we're here at the Maryland Women's Heritage Center, and I love this place. The Maryland Women's Heritage Center has many opportunities in STEM careers for women. I, though, prefer a career in show business. I love hosting Teen Scene. I'm attending the Broadcasting Institute of Maryland, where I'm learning the profession of becoming a news anchor. Best experience at the Broadcasting Institute of Maryland is being in the studio, voice recording, and making commercials. My favorite instructors is Mr. John Carrington. He's a great guy, he's really funny, and he has a lot of talent. He's great at teaching. He makes learning very fun. I believe that I can learn a lot from him. I like the fact that he does magic while teaching. And I hope that that same magic could make me a news anchor someday. So if you're interested in having me as your next host on your show, you can reach me at abrown148@hotmail.com. That's abrown148@hotmail.com. We'll be right back, so don't go away. Welcome back. I hope you're enjoying the show. Today we're going to take you to School Court TV, where kids are learning how to deal with real life situations.
Welcome to School Court TV. Today we have a special case for you. It's an appeals case from Season 1. We're featuring student attorney Byron Johns versus student attorney Angelica Brown in Smith versus the State of Maryland. Now this is unique because it's an appeals case from Season 1, but I invite you to stay tuned. This is School Court TV.
All rise. School Court is now in session. The Honorable Judge David Paulson now presiding. First case on the docket is case number 009, Smith Motor Sales versus the State of Maryland. If you have all cell phones, please turn them off at this time.
Thank you, Ben. Please be seated. Good morning.
Good morning.
First thing we're going to do is figure out who our lawyers are in the courtroom today. Would you please, let's start with the plaintiff first. Rise and introduce yourself.
Hello, I'm attorney Angelica Brown representing Mr. Smith.
And for the state?
Good evening, I'm Byron Johns and I'm the counsel for the State of Maryland.
Thank you very much. Mr. Johns, you may be seated. If we can, we want to begin with opening arguments, and we're going to begin in this case, obviously, with the plaintiff. Ms. Brown, if you begin.
On April 1st, 2004, 8 police officers, 1 zoning officer, and 2 environmental officers wrongfully entered my client's property, Mr. Smith's Motor Sales. They ordered him to open his private-owned gate, and once he opened his gate, they removed 61 vehicles from his private fenced lot. On April 1st, they gave various reasons why they wanted to tow their cars. They gave many citations, which were 4, and they said there was alleged leaking oil and hazardous conditions, but if you read on all 4 of those citations that there were none of the leaking oil. When my client, Mr. Smith, asked for a court order or a warrant, they said they did not have one. William Conkling said to the city inspector, warned him that he had all related permits. He told them to go away, but once the police officers were warned, they still continued, one by one, towed all 61 of his cars. My client is suing the city of Baltimore for $582,000 for profit loss from 61 cars sitting on the towed lot, $82,000 in attorney fees, and $800 loss in violation of his 4th Amendment constitutional rights, mental stress, trauma, and time lost from his family and business relationships that he could have earned. That is
How much for violation of the constitutional rights?
$800,000.
$800,000.
Yes.
And $82,000 for what essentially is your fee.
And court fees,
Are
too.
you prepared to justify that $82,000?
Yes,
Okay.
Your Honor.
Are you finished?
Yes.
All right. For the state, Mr. Johns, if you would.
Your Honor, I would like to remind the court that this matter is being brought forward on appeal, and the facts raised by counsel for Smith Motors, while they may be of interest, they were all litigated in the lower court by Judge Cannon. And my client, the State of Maryland, received favorable decision. We won. Before the court today, the burden is on Smith Motors to prove that the lower court made a reversible error in reaching its decision, and that is a high standard. Well, today, Your Honor, the counsel, Smith Motors, is making the claim that her client's Fourth Amendment constitutional rights were violated, as claimed and denied for the lower court. On this matter, the discovery of certain actions that are non-searches do not require a Fourth Amendment search and are not protected by the Fourth Amendment. Smith Motors had derelict and abandoned cars, car parts, cut metal, and debris visibly throughout, internally and externally, on his property. The business operated as a chop shop and not in accordance with the used car sales.
Excuse me, counsel, were the facts in the original case about a chop shop, or was it about a repair shop? You know, chop shop in a court of law can have a...
It is a repair, yes, Your Honor, it was a repair shop, but they...
Was he charged with any crime related to stolen or otherwise mishandled vehicles?
No, but he was getting scrap metal and putting them together, trying to sell cars that would run on city streets.
Thank you. Go ahead and proceed.
And what he was doing with his business was not in accordance with what his permit was granted, creating a safety and environmental hazard and diminishing the quality of life in the community. As Smith Motors has violations of the city ordinances in plain view, the plain view doctrine technically states that no Fourth Amendment search occurred and is exception to the warrant requirement. The police were lawfully in a position from which they viewed objects were incriminating and given the existence of unabated citations. The officers had a lawful right to access the business premise and seize the cars without a warrant.
Now, the facts in the original case, as I understand it, didn't dispute that. This lawsuit is about whether or not the officers had the right and indeed the duty to remove said vehicles from the property and keep the vehicles for how long, do we know?
3 years.
3 years?
Yes, Your Honor. Well, the storage of the vehicles violated many zoning laws, and there is a law in the city of Baltimore stating that if stored vehicles violate zoning laws of the city of Baltimore, they are deemed abandoned, and abandoned cars are therefore rightfully supposed to be taken out by the city of Baltimore. And therefore, we did not violate her Fourth Amendment rights by going in unlawfully and seizing these vehicles, because we had the right to, and that was under one of the laws that the Baltimore has.
Did the police officers have a warrant?
No, they did not have a warrant.
To search the premises. Is it your position that they didn't need a warrant?
Yes.
And it's your position because they didn't need a warrant because?
Because there's a law in Baltimore saying that if stored vehicles violate zoning laws, they are deemed abandoned and are supposed to be taken off the property.
Anything else?
Yes, Your Honor. Furthermore, this case also has to do with the 14th Amendment, which provides, in relevant part, nor shall any state deprive any person of life, liberty, or property without due process of law. Well, Your Honor, on the matter as whether Smith Motors was afforded due process, we submit the following facts. We take no issue to the fact that Smith Motors operated a business under a permit, but the facts are that the work that was being routinely done at the business location operated outside the scope of the permits that were granted. Smith Motors has argued that their due process rights were violated, but they received verbal and written notice and citations of violations in April 2004 for failure to comply with explicit ordinances a full 12 months prior to the confiscation. Thus, he had ample opportunity to cure the violations, and he opted not to do so. They chose not to respond to the notices nor bring his business into compliance. The officers were performing their sworn duties as law enforcement as defined with Maryland statutes when they confiscated the cars to abate the violations. With respect to the applicant's claim for damages As noted, he failed to respond to the 2004 citations. Furthermore, had an obligation to minimize damages, which he did not, instead choosing to be obstinate. Thus, his own actions significantly contributed to the alleged damages, which he would like this court to levy on the taxpayers of the state of Maryland. If the damages to the business were in fact as significant as alleged, a reasonable person would have paid the $6,600 and sued for that money, but instead they chose to spend $82,000 in legal fees, delay the return of his vehicles by several years, and attempt to extort from the state of Maryland.
Counsel, can you explain to me why the city didn't return the cars immediately?
Well, there was a fee of the $6,600, and he chose not to pay that fee.
He pursued an action in court of law?
Yes.
Okay.
And instead, he chose to pay $82,000 in law fees, right, and then sue for over $1 million in financial gains from junk assets that he acknowledged cost no more than $66,000.
You've got more, right?
No.
Have a seat. I want before we go further,
Your Honor.
Don't forget what else you're going to say, but before we go further, you can sit down.
Wasn't that fantastic? Well, don't go anywhere. We'll be right back.
Farzan Mohammed, visionary and creator of School Corps TV. Ambition of this show, to create and develop leadership in our youth through researching facts, developing and presenting those facts effectively in written and verbal form. To quote Mr. Mohammed, to have our youth see any situation from inside the box, outside the box, and around the box.
Welcome back. Hey teens, I understand that high school is pretty hard at times, but stick in there. One of the best things that I've experienced in high school was graduating with honors. Now I'm 19 and I feel like I can conquer the world. I know that sometimes it is tough to deal with peer pressure and kids around you who aren't staying focused, but stay true to yourself. Some of the programs that I was involved in that helped me stay out of trouble were the basketball team, the girls basketball team, and the debate team. Playing basketball kept me in good shape, and the debate team helped me to stay focused on becoming a better communicator. I don't want to preach to you too much, but I hope that some of my experiences can help you too. Education is the key, so stay focused, stay in touch, and stay tuned. We have another great clip for you. Look at this.
Okay.
Before we go further, I want plaintiff counsel to respond to some or all of that if you have anything. Please stand.
Your Honor, if it was abandoned cars on his lot, if it was abandoned, it's in his lot, so it's not abandoned. All his citations...
Is there a lock on the gate?
Yes, it's on his private-owned 6-foot chain link.
He owns the property?
Yes.
Okay.
It's an enclosed gate, so if it's abandoned, I don't understand how it could be abandoned if it's on his lot. If it was outside of his lot on the parked road, then yes, maybe. And if there's many different parts, it's a repair shop. Of course, there's going to be random pieces like an engine or something because they're repairing cars to sell them. So I don't understand how it can be abandoned or unused parts if they're using all of them.
Can you describe for me the nature of the neighborhood in which this business is located?
It's on 1330 East Patasco with, it's a business around a neighborhood, but it's also a chain link fence. So unless you're opened into that property to come in, you can't really see.
Are there residential neighborhoods nearby?
Yes, sir.
And
Your Honor.
so is this within view of those residential neighborhoods?
Not unless the gate
What
is
I'm trying to
open.
get to is, there were complaints filed against this business with the city, correct? Were there no complaints?
There were no complaints to my plaintiff's
Well,
record.
I'll get to the I'll get to the defendant's side on that when I ask those questions. Okay, continue.
And also, why would we pay $6,000 for the police officers wrongfully doing? They had no court order, and after 2 people had told them to stop and go away, but they proceeded to disobey and take all 61 cars away. So why would we pay for their mistake? I don't get that. And also, if this is so-called unlawful cars, why would they not give a warning? The only warnings we had were 4 citations issued on that day for leaking oil. And the citations that they gave were no leaking oil.
Objection, Your Honor.
Yes, stand. What's your objection?
They were given many warnings, verbal and written.
On that day?
No, a year before the cars were even confiscated. A year before, April 2004, multiple written and verbal citations and warnings.
When they were called, when I was called, my client showed them all permits. Everything was up to date, and I don't know if they weren't up to date. If we disobeyed stuff, then why would they send them away?
Was it part of your argument that the city, that the officials on the scene at the time called into a supervisor who said to discontinue what you're doing and we'll come back at a later time?
Yes, Your Honor.
And you had verified that in the previous court hearings?
Yes, Your Honor.
How do you respond to that, counsel?
I don't believe that the people who were telling them to go away understood the prior things that they've been through, of how they've warned them many times about how what they're doing is violating many zoning laws. They've gave them warnings ample time before so he could respond, and they chose to ignore these warnings. So under Baltimore's law, if a stored car is breaking zoning laws, it is therefore deemed abandoned, no matter where it is. If a stored car is breaking zoning laws, it is therefore abandoned, which should be removed from the property.
Your Honor, we weren't breaking any laws because we had no warning. I highly doubt that a state's attorney office I highly doubt that a state's attorney office would send police officers away if he was not completely sure that they had all permits related. If the permits were up to date, I would surely understand if he would take 61 cars away.
Let me ask you a question. Why didn't your client pay the city $6,500, $6,400, $6,600, whatever it was, in order to get the cars back earlier, and then go to court to get a return of that money, or argue that case at a later time? Couldn't your client have taken possession of those cars back from the city far earlier than 3 years?
Yes, Your Honor, you could, but why would we pay for someone's mistake? We are basically saying, you can take my cars away, I'll pay the $6,000, and you can get away with it.
Counselor, sounds like ransom. Sounds to me like the government you represent, and I understand you represent the state, and the state is the employer for these police officers, but the city was involved with the situation. I understand you don't represent the city. Congratulations for that. But I understand that they took possession of these cars, and it's as if they were holding them ransom. How is that not ransom? Here, we're going to take your cars. You have to pay us over $6,000 just to get them back. In a situation like this, I'm not sure that they should have taken possession, and apparently somebody agreed with me at the time, whether they should have taken possession of those cars to begin with.
One thing, Your Honor, the permit that they have is for minor repairs of vehicles. They were getting scrap metal and trying to build vehicles so they could sell them and use them on city streets. And
what you're saying is that the city, that the business in question received permits, some valid permits, and they had those permits in their possession. Correct, counsel?
Mm-hmm. Yes, sir.
But the business itself was
violating those permits.
Violating those permits by taking the business far beyond the nature of those businesses.
Yes, and we've had complaints from neighbors saying it's a disturbance because it is in plain view. And, Your Honor, they brought unlicensed, unregistered, inoperable vehicles to the property, which violates zoning laws.
Counselor?
That's not true, because when the police officers asked my client, can we have all license, registration, permits, every 61 vehicles had correct permits, were up to date, they had to correct everything. And if my client's on the lot every day...
Those records were provided to the police officers at the time?
Yes, Your Honor.
Counselor, you have something to add?
That's not true, Your Honor. they did bring unlicensed and unregistered vehicles onto their property. And
I'm not going to go into this very far,
right,
because this has been adjudicated at a previous court. I understand that. What we're dealing with, there are some issues far from this, but it's providing us with some understanding as to where this case is going. Counselor, Ms. Brown, if your client, I'm having difficulty understanding why it is police and all these other people show up at your client's business out of the blue without complaints to do what it is they did. Are you telling me your client did nothing wrong, didn't violate any of the permits? Is that what you're saying?
Yes, Your Honor, that's exactly what I'm saying.
Counselor, has the city or did the state or anybody go back in and prosecute this individual for violating the permits?
Can you repeat that question, sir?
Did the city or the state or anybody at a later time go back in and prosecute this individual, charge them with any crime, or did you shut down the business? What happened subsequent to the confiscation of the vehicle?
Well, again, they had these vehicles and they were violating zoning laws, so we gave them citations for violating zoning laws. 2-401, 3-106, 3-107, and 3-107A2 and 3-107A3. Those 4 citations. Those are the laws they broke.
What do you say to the allegation, at least from them, and I think the evidence in the testimony previously had indicated, that somebody back in the office said, just stop what you're doing, let's pull everybody back, we can reconnoiter at a later time, and if they're violating the law, and if they're doing things wrong with this property, come back and we'll go do it again. What do you say to that allegation? Why? Are you saying to me that police officers didn't overreach their scope of authority in this particular case?
I don't think they did, Your Honor. Because they gave time. They respectfully gave them many warnings. Respectfully asked them to please follow the laws here, or we're going to have to confiscate your cars. And again, they didn't respond to anything and just ignored it. So in the middle of the process, when someone says, oh, okay, let's come back tomorrow, if it's already halfway done, and we're not violating any Fourth Amendment rights, we have a right to confiscate these cars.
City law actually says that if a car is, please describe that for me again, because I'm a little confused. Yes. Her argument is good. Her argument says that those cars were on private property, in a licensed business, inside a locked fence, when the officers and the others arrived that morning to do whatever it is they were going to do. How is that abandonment?
It is abandoned because under Baltimore City Code 31-8 states that when the storage of a vehicle violates the zoning laws, which it did, the vehicle is deemed abandoned and may be towed or otherwise removed from the property, any property. It could be private property, public property, but if it violates zoning laws of Maryland, which we gave her many warnings saying that they were in ample time, then it is therefore deemed abandoned and should be taken off the property.
All right. At this time, let me allow the two of you to give your closing arguments. Ms. Brown, if you would begin.
Your Honor, I understand that they came in because it was abandoned, but if my client is on his lot working every day, how could they be abandoned? And the definition of repair is using now or later for other things. And there was no proof, no warning of any zoning laws, any citations that they had ordered. Like I've said before previously, the only citations were 4 issued that day for alleged leaking oil, but we discussed in the previous case that the citations never said anything about hazardous conditions or leaking oil. And also, within a certain date of a citation, they could give a warning, and within 24 hours, 36, 48 hours, we could have fixed the problems that they so-called put on their citation. But Your Honor, we had given no warning. The alleged citations and other that he was talking about for abandoned lots, scrap metals. There's no proof of that, and we had never got any of that.
Mr. Johns, thank you.
In no way do I feel the state of Maryland violated her Fourth Amendment rights. And the reason why they were abandoned, maybe he was working there every day, 24 hours a day, and he was committed and was running a well-run business. But the fact that they violated laws of City of Baltimore, which again, a year before, we warned her many times, orally and written and orally, that
I got what you meant.
Right. that it was breaking these laws, and if she didn't fix it, we told them if he did not fix it, we were going to tow the vehicles. Mm-hmm. He chose to ignore it, and so by the City of Baltimore City Code 31-8, they're claimed abandoned, and we are therefore rightfully allowed to go and tow these vehicles without breaking any Fourth Amendment rights of search and seizure, Your Honor.
Well, I know you at home have a lot to say about this case, right? Well, please sound off on Facebook. We look forward to your comments. www.facebook.com/SchoolCourtTV. You can also check us out on the web at schoolcourt.org.
Very much, both of you did an excellent job arguing your cases, and this is a tough one to decide. While I find that there was probable cause, obviously, for entry into the property and to accomplish whatever it is the mission was of the law enforcement officers that day, I'm finding that the city had no cause to take control of these 91 vehicles and keep them for 3 years at the expense of the taxpayers. I am agreeing, however, with the state that there is no Fourth Amendment violation in this case. If this particular business did create an eyesore and did have communications with the city from time and time again over the previous year to fix and correct certain violations that the city may have found, that's fine. But in this particular case, I don't think that your argument regarding a Fourth Amendment violation is well taken, and I am going to reject that in the plaintiff's plea. However, the plaintiff was damaged. The business in this particular case lost possession and the ability to sell and do whatever he wishes with that property for over 3 years, as I understand it, and has brought this case through the courts and wasted much time, as I understand it, much to the expense of him, and of course that includes his legal expenses. However, because you have received the property back previously and had the ability, even though at a reduced amount, I'm not going to grant the entire $500,000 for the property loss. We're going to have to justify the loss at a later proceeding. I am estimating that loss to be something between $200,000 and $300,000, and I am granting reasonable attorney fees of $82,000 to the plaintiff.
School court battle. In school court they learn how to debate in the best of manners. First they get hired, get a smile from employer, preparing out future business leaders and lawyers. Learn how to fact find info on the back like competitors like football sack time. Whether a defendant or plaintiff, I won't bend, and I will do the best that I can in school court.
Wasn't that great? I hope you enjoyed it. This is another episode of Teen Scene from the Maryland Women's Heritage Center. I'm your host, Ariel Brown. See you next time.